This video is for people who want to bring or defend an employment tribunal claim about disability discrimination at work. It explains what happens when there is a dispute about whether or not a claimant is disabled. What I'm going to tell you is quite complicated, and you may find it helpful to pause the video at times and replay it. There is also another video which explains who counts as disabled. Because this video uses some of the words and phrases which are explained in that video, it may be helpful to watch that video first. When a claimant brings a claim of disability discrimination, there will always be a preliminary case management hearing in front of a judge before the claim proceeds to a final hearing. The judge will discuss what information and documents need to be obtained or prepared to deal with the question of disability, and then make orders. The judge's orders will depend on whether the employer agrees whether or not the claimant is disabled. There are three possibilities. The employer agrees the claimant was disabled at the relevant time. The employer wants more information before they agree whether or not the claimant is disabled. The employer denies that the claimant was disabled at the relevant time. Where the employer does not agree that the claimant is disabled, the judge dealing with the case will order the claimant to do two things by a set date. The first is to provide the employer with relevant medical evidence. The second is to prepare a document called an impact statement. I will explain what each of these involve in more detail in a moment. The judge will also order the employer to read the documents and by a set date say in writing whether they now agree whether or not the claimant was disabled. If they still do not agree, they must explain why. If the employer still does not agree that the claimant is disabled, the tribunal will need to decide this. This may be at another preliminary hearing held in public this time, or maybe at the final hearing. Where a judge orders the claimant to provide medical evidence, the claimant will need to get their medical notes from their GP and any other doctors or people that have been treating them. The type of evidence could be GP notes, consultant letters, medical reports, occupational health reports, and occupational health assessments. The claimant could also ask a doctor to write a letter or report for them. The medical evidence should go back to the date when the claimant first spoke to their doctors about their medical condition. The evidence only needs to focus on the medical condition or conditions the claimant says mean they are a disabled person. Medical notes about other illnesses, conditions can be hidden. Both sides need to have a copy of all of the medical evidence, so when the claimant sends the notes to the employer, they need to keep their own copy. There is no need to send a copy to the tribunal initially. An impact statement is a witness statement a claimant writes to explain the impact that their medical condition has on them. The document should be typed with numbered paragraphs. It should begin by explaining what impairment the claimant has and how long they have had it. The statement should explain the symptoms of the medical condition, but it needs to do more than this. The main focus should be on explaining the impact of those symptoms on the claimant's ability to do normal everyday activities. For example, instead of a claimant just saying that their impairment causes them to be in pain all the time, they should also write about how this impacts on their ability to do normal day-to-day activities. They might say that because they are in pain, they do not go out to the cinema, or their partner has to do the shopping rather than them doing it. A good place for a claimant to start is to think of everything they do during a normal day, from getting up in the morning to going to bed at night, and then write about which of these activities are impacted by their impairment. The more examples that are included in the impact statement, the easier it is for the tribunal and the employer to understand. People often forget about or play down the negative impacts of their impairments because they have got used to workarounds or are embarrassed. Claimants should not exaggerate the position, however, and need to be honest. They may be questioned about what they have said. The statement also needs to explain what treatments the claimant has had and when these took place, including any changes. If the claimant relies on medication or aids, they should say what the impact of their impairment would be if they didn't take the medication or use the aid. The statement should not focus on the position at the time of the tribunal hearing. What is most important is the impact the impairment was having on the claimant at the relevant time, that is, the date the claimant says they were discriminated against. If the claimant's condition has changed over time or has a variable effect, the claimant will need to explain how and when this happened. It is important to be as accurate as possible with dates and timings. For a changing condition, for example, the claimant might say, "From February 2024, I started to have difficulty walking. It was only slightly painful at first, but by about August 2024, I found that I could not walk further than the end of the street." For a variable condition, the claimant might say, "My symptoms vary on a daily basis. On about half the days in every week, I'm unable to get out of bed due to my depression. On the other days, I can get out of bed and do some indoor activities, such as watch television and make myself food. I do not, however, feel able to leave the house." To prove the condition is long-term, the claimant may also want to describe the position 12 months before the relevant time, or explain how long the impairment has been impacting on them. Some people want to keep information about their medical conditions private. If a claimant is worried about this, they can ask the tribunal to make orders to protect their privacy. These are known as Rule 50 orders. The first hearing in the case will be a private hearing, so it is a good time to talk about any privacy concerns with the judge. Claimants will need to share all their medical information with their employer and its lawyers, but they can ask that only certain people are allowed to see the information. They can also ask that the information is not shared with members of the public. There are lots of places to look if you want further information. In this slide, I have identified the main pieces of legislation that apply and where to find them, as well as some other places to look too. I would encourage you to seek legal advice. Thank you for watching. I hope you have found this video helpful.